Yeah. We're doing, we're already on. Okay, we are on the record. This is the people of the state of Michigan versus Irarian Dwayne Stevenson, 2355231. Mr. Stevenson is charged with 1 count of weapons carrying concealed with a felony commission with a motor vehicle adult advisory. They set for a probable cause conference. The prosecutor is not present as of yet. Attorney Roberts, can you put your appearance on the record?
Yes, good morning, Your Honor, court staff, Jonathan Roberts, P 86428, on behalf of Mr. Stevenson, who is present on Zoom. Mr. Stevenson, could you please state your name for the court?
Yes, Arion Stevenson.
Good morning.
Good morning.
And is it correct, Attorney Roberts, you're just looking for an exam date today?
Yes.
Okay. Let's see here. You have March 10th available?
I believe I will be in your court on a separate matter at that day. Let me check to see what time that would be.
Okay.
Yeah, so I have one probable cause conference at 8:30 in front of Your Honor on that day. So I should be available anytime after that.
How about we just do 8:30? You could be the first case we call.
That works, Your Honor. Thank you.
Okay. Mr. Stevenson, your exam has been set for March 10th at 8:30 a.m. at 36th District Court. That'll be in person. You understand that?
Yes, ma'am.
Okay, anything else?
That's all from defense, Your Honor. Thank you.
Okay. You all have a good day.
You as well. Thanks.
You too.
You can log off.
To the gentleman with the hoodie on, Vortex Z22 device. What's your name, sir? With the black hoodie on with designs on it?
Hello.
Yes, what's your name?
I'm calling in for my son, Howard Winston.
You're doing what?
Standing for my son, Howard Winston.
You're standing in for him?
No, he is right beside me. Talk to him. Hello.
Okay, good morning, sir.
Good morning.
Okay, I have you checked in. I don't have your attorney present as of yet. I'm gonna put your device on mute until your attorney checks in.
All right.
Person with the iPhone with no name, video on, can you unmute your device and state your name, please?
Martell Watkins.
I didn't hear your last name.
Watkins.
Okay, I have you checked in, Mr. Watkins.
Thank
I'm gonna put you until your attorney shows up.
you.
Okay, we can handle Doherty. We ready on Doherty?
Ready.
Okay, we're on the record of the people of the state of Michigan versus Stephen Doherty, case number 2355580. Mr. Doherty is charged with count one, weapons, firearms, discharge, in or out of building. Count two, weapons, firearms, possession by felon. Count three, weapons carrying concealed. Count four, count five, both weapons, some firearms with the habitual offender fourth offense notice. They set for a probable cause conference appearances.
Good morning, Your Honor. Good morning, everyone. Danielle Parrish on behalf of the people, P85495.
Top of the morning, Judge Dwayne Boyd, P 79612, standing in for the attorney of record, Jeffrey Edison, with Mr. Doherty's consent. Would you please state your name for the record, sir? You have to unmute yourself.
Stephen Doherty.
Good morning, everybody.
Good
Judge,
morning.
today is the date and time for an adjourned PCC in this matter. We're asking for an exam.
Okay, so you have your discovery.
I believe so. I think it's complete.
Okay. I have March 10th at 11 o'clock as the earliest date.
I have a conflict for the 10th, Judge.
Okay. How about the 14th at 9 o'clock?
That works.
Okay, anything else?
The 10th is satisfied.
Mr. Doherty, that'll be in person, March 14th at 9 o'clock at 36th District Court, okay?
Yes, ma'am.
Yes, ma'am.
Thank you. Have a good rest of your day, Judge.
You as well, both of you. Right. I'm sorry. You say you too. We set up, we saw the message.
I think for April Fool's, I was thinking of something like. Your Honor, would you like for April Fool's? I was thinking that when I zoomed in the other day, if I just play a joke, but I'm like a moo like I'm in my pajamas, so.
Mr. Rush, good morning. Have you checked in? Your lawyer has not checked in yet.
Good morning.
We're just waiting on your attorney.
Okay.
What's going on outside? Is there an event?
MSSA wrestling.
What is it?
Wrestling.
Wrestling.
I think
Oh, okay. I was wondering, I'm like,
it's back, yeah.
yeah.
I
was like, I don't know of any sports things that are going on, but.
Yes, ma'am.
Yeah, tell his hands to get over here, rest him up.
Okay, so.
Do you know if this guy's laptop?
No, he's on the tablet
Got it. Okay, all right.
He's got that
now. Yeah, got it.
one.
Got it. It's on electric monitor.
Oh, okay.
Yep.
It'll be a horrible one.
Yeah.
Attorney Sala,
Good morning.
good morning, how are you?
I'm doing amazing. How are you? Happy Friday.
Happy Friday. Your client's checked in. Do you need to talk to him?
I do not. We spoke yesterday evening.
Okay, as soon as I get off the phone, I can call your case.
Thank you.
Oh, you said Russian? Okay. You didn't have to say the rest of it. So you should get Judge Larry Williams. Well, you can still call in. I'll be out, regular telephone. Party spot?
Yes.
Yes, so then you have to put in a Zoom mic.
Yes,
Your client's present. Do you need to speak to him before we go on the record?
no, I think we're waiting for the competency and criminal responsibility report.
Okay, give me one moment. All right, so the Zoom information after you dial 929. Just find it. Just find one. Put it in your phone. A cell phone? Put it in your notes or something. Just text it in your phone. Somewhere. Insurance online. Oh, I'm sorry. I was trying to call the turn. Thank you to answer. Okay, it's 360. 332. 000. think you should be good for. My number is, they'll ask you to put in the Zoom mic. Mr. Demonte Rush.
Yes.
Okay, this is case number 215909. The people of the state of Michigan versus Demonte Rush. Mr. Rush, one moment, is charged with one count of weapons carrying concealed. They set for a probable cause conference appearances.
Good morning, Your Honor. Danielle Search on behalf of people P85495.
And good morning, Your Honor. Mohammed Saban on behalf of Mr. Rush, P83365. Demonte Rush, may you please present yourself to the court?
Good morning. My name is Damani Rush.
And any issues with discovery?
None, Your Honor.
Okay, are you ready to set the exam date?
Apologies, I didn't hear you. Some back.
Are you ready to set the exam date?
Yes, we are.
I have at the earliest March 10th at 11 o'clock.
March 10th, a week from today at 11 o'clock.
Yes.
Your Honor, last time we were in this court, I believe we set a date, unless I'm mistaken.
Let's see.
We had set it for the 17th, but I can move it to the 10th if you would like.
If it works for you all, I can move to the 10th. It'll help my numbers as well. It's up to you.
Yeah, the 10th is fine.
Okay, let's do the 10th at 11.
Okay. Sounds good. Okay, thank you.
You're welcome. So Mr. Rush, that'll be in person at 36th District Court, March 10th at 11 o'clock, okay?
Okay.
All right, anything else on the record?
None, thank you, Your Honor.
All right, you all have a good rest of your day.
You too.
Howard Winston next. No report on Winston, correct? Okay, this is people of the state of Michigan versus Howard Winston, 225871. Mr. Winston is charged with one count of stolen property, receiving and concealing a motor vehicle. Today's set for a competency hearing. Appearances.
Good morning, Your Honor. Danielle Search on behalf of people P85495.
And good morning, Your Honor. Janet Spand appearing on behalf of Howard Winston, P43281.
Mr. Winston, can you unmute your device and state your name, please? Say it one more time, your audio went out.
Howard Winston.
Thank you. You're here for a competency hearing. I don't believe there's a report provided as of yet. Is that correct, Attorney Spahn?
That's my understanding. I believe I received an email from the Forensic Center maybe a week or so ago indicating that it was going to take them some additional time to do the report.
Did they say about how much time?
No, they did not.
Okay. You want to try another 30 days? How about 30 days out?
Oh, 30 days? I'm sorry, I couldn't hear you. Sure.
Okay, let's see here. Let's get an exact date.
Oh, it's 6. It's the 6.
It's the 6th, Passover and Good Friday. All right, so how about April 4th?
Sure, that'll still be by Zoom, correct?
Correct, then we'll do 8:45, that works?
That's fine.
Okay, all right, Mr.
All right.
Winston, hopefully with the report in about 30 days on April 4th at 8:45. You can still log on Zoom, you do not have to come in person, okay?
All right.
Okay, you have a good day.
All right, thank you. Have a good weekend, everybody.
Okay.
Attorney Wallhorn, are you ready for your case to be called, or would you like to wait a little bit longer?
I think I would wait a little longer.
Okay, we have things to take care
How about 9:15?
of. That works.
Thank you.
Got the OIC also.
David Bradley, is that what you're getting ready to do? Who is the person logged in with the phone number 241-1545? Raise your hand. Phone number 241-1545. Please state your name.
Oh, sorry, Robert Jones Jr.
Mr. Jones Jr., what type of matter do you have today?
Ma'am,
What type of case?
I got a misdemeanor drug violation.
Okay, you should be in Judge Larry Williams' courtroom. So you know that 999 number that you dialed?
Yes.
Okay, when you put in the Zoom ID, put in, let me know when you're ready to write down the correct number.
Good morning, Your Honor.
Good morning. Thank you for zooming in.
I got Mr. Daniel Phelps.
Okay, I'm getting the file in about 2 seconds. Actually, like a minute. So the gentleman who I'm trying to get to the right courtroom, are you ready to write the number down?
I ain't got no pen. Yes, ma'am.
So after you dial the 929 number, put in 360
360
332
332
0000.
332 0000. Okay.
40. That's Judge Larry Williams. So go ahead and log on now.
Okay.
Good morning, no, that ain't gonna.
Everybody logged off.
This case. Phelps. Doing that, report back to my doing that case. Yes, she on.
Oh, okay.
Right here, just give me the file, I ain't going nowhere.
Okay, are we ready on Phelps?
Yes, Judge.
Okay. This is case 2355699, people of the state of Michigan versus Daniel Earl Phelps. Mr. Phelps is charged with the following: count 1, criminal sexual conduct, first degree relationship. Count 2, criminal sexual conduct, first degree relationship. Count 3, criminal sexual conduct, first degree relationship, as well as count 4, 5, 6, 7, all criminal sexual conduct, first degree relationship. Today's date, I believe was this for the probable cause conference? Is that correct?
Yes, Judge.
Okay, and here is matter to address, bond?
Yes, Judge.
Okay, I'm assuming defense counsel wants to begin?
Yes, so Mr. Phelps is currently held on a 100,000 10% cash bond, Judge, or excuse me, 100,000 10% bond. And Mr. Phelps has been held since February 21st on that bond, so it is not affordable for Mr. Phelps. And of course, cash bond should be the rare exception now in the 36th District Court. I'm asking for Mr. Phelps to be released on a personal bond. He has a stable residence. He's been living there for the past 5 years. He would not be living with the alleged victim in this case. Mr. Phelps works for Uber, so he has a job, he has an income that he needs to get back to. And these are, of course, allegations against Mr. Phelps. Mr. Phelps is 39 years old. He has no criminal record. And while, of course, these are serious charges, Judge, there was no violence alleged, there was no physical harm alleged. And so, Judge, for all those reasons, Mr. Phelps will not be a danger to the community if he's released and will not be at risk of failing to appear.
And I'm sorry, I forgot to ask for appearances. Can everybody put their appearances on, please?
Of course.
Yeah, good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
And good morning, Judge. Neighborhood Defender Service by Hannah Barron, P85265.
And Mr. Phelps, can you state your full name for the record, please?
Good morning, Judge. My name is Daniel Earl Phelps II.
Thank you. And APA Ripley, do you have a response?
Yes, Your Honor. I guess I'm unclear as to what his bond is at this point. On the 36th District ROA, it shows 10,000 10%. So I'm not sure if that was a typo because defense counsel stated 100,000. I was asking to adjust bond anyway because 10,000, 10% I think is incredibly low for a case like this. And it was lowered at the bond redetermination hearing, Your Honor. It was originally set at 500,000 cash. It was lowered at the bond redetermination by Judge Larry Williams to, I guess, 100,000, 10%. We would object to any further lowering. We would request a DSU in this case if the judge would, be inclined to do that. This case did clearly already go through a bond redetermination hearing where the other judge felt it was lowered to 100,000. The charges in this case are incredibly serious. They are life offenses. Your Honor, I think that there is a danger to the community in the fact that the defendant's reasoning behind this is that he has a very bad drinking problem and very vivid dreams in which he has sexual relations with a 15-year-old girl who, although may have, she can't consent, Your Honor. A 15-year-old cannot consent. So that's the whole issue in this case. And so I would just want to clarify what exactly the bond is currently.
Okay. So the bond is correct, APA Ripley. It was reduced to 10,000, 10% on February 27th of this year by Judge Larry Williams. Are you aware of that, Attorney?
No, I wasn't, Judge. For some reason, the judge has him held on a 100,000, 10%, so on a 10,000 bond. But that's clarifying.
Yeah, I just printed, or the clerk just printed out an updated RO that's 10,000, 10%.
So, Your Honor, if that is the case, that it is truly 10,000, 10%, the people believe that that bond is incredibly low for a case like this. And I don't think it accurately reflects the danger to the community in this case, which I had just gone over. We would be requesting a DSU.
I will definitely order a DSU report. And I'm going to leave bond as it is, but I need to see what the conditions are if he were to post what it says here. So it says currently no contact with victim directly or indirectly, tether requirement, GPS tether requirement for house arrest, allow for travel for work only, and that's it. So I am not going to change any of that. If he were to post the bond, he is going to have to be on house arrest. And of course, by the location where the alleged victim lives or frequents, and he's not in contact, of course, that complainant witness directly or indirectly. And I will have a DSU report ordered.
Thank you, Judge.
Thank you, Your Honor.
Anything else?
No, if I could just get a breakout room with Mr. Phelps once we're off the record.
We are off the record. That Mr. Phelps, I'm going to put you into a breakout room so you can speak to your client. To your attorney.
Thank you.
Oh, and just for the record, the exam date is set for March 20th at 9 a.m.
Yes, Judge. Thank you.
Yep.
Hey, Ben.
Good morning.
Good morning. How are you?
I'm good. How are you?
Pretty good. It's Friday.
Drive safely today with that weather.
Okay, you too.
Bye.
Have a good week. the person with the phone number ending in 1545. What is your name?
Robert Jones.
Mr. Jones, you should be in courtroom 332 of Judge Larry Williams. We have switched dockets. Let me know when you're ready to take down the correct Zoom information.
I just tried to do that. That's why I called back. I mean, like, I'm just sitting there. I ain't hear nothing.
Were you sitting there because you had to wait? Or were you in the wrong
Yeah,
court?
I was just almost in the room. They told me to hold on 1 second, and I held on for a couple of minutes. I ain't hear nothing.
Okay, but that's the right courtroom. What do you want me to do about how long you have to wait? This is the wrong courtroom. I'm not traffic control. I have a whole docket I'm handling here.
No.
Right. We're supposed to be in courtroom
Okay, so
332. Just wait.
okay. So what number do I dial?
Same number that you dialed to get in there when they told you to wait.
Ma'am?
Same number that you dialed when you said you called in there and they told you to wait, dial that number again.
Okay.
So it's a large docket. The traffic matters, it's several people. You have to wait. They'll get to you. You have to be a little patient.
Okay.
So I'm in the waiting room. Mr. Phelps, you're set for today. We're not going on the record anymore in your case.
Thanks, Your Honor.
Go have a good one. Attorney Carson, good morning.
Good morning. I'm here on Makai Gilmer.
Okay, Mr. Gilmer. He's not here. Okay. It's set for an exam today.
I know I was going to ask for an adjournment. I am out of town. My father's in intensive care.
Gilmer.
Yeah, we have,
Everybody here.
but I mean. I was just going to say, I obviously family matters, emergency, I understand that. Can I ask why?
Case 2355470, the people of the state of Michigan versus Makai Gilmer. Mr. Gilmer is charged with count 1, larceny from motor vehicle, count 2, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Today is the day set for a preliminary examination appearances.
Good morning, Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Stephanie Carson on behalf of Mr. Gilmer, P57096.
And have you spoken to Mr. Gilmer?
No, Your Honor, I have not. I did attempt to reach out. I could not locate him. I also tried to get someone to cover the exam, but it was Friday and most people were busy and I didn't want to have the court waiting.
Okay, people ready to proceed today?
Yes, Your Honor. All of our witnesses are here. I understand Ms. Carson's dilemma. However, the defendant does not have the same situation as her, and the defendant is not here. Therefore, the people are going to ask that a capias be placed.
Your Honor, I cannot explain my client's absence. I leave it to the discretion of the court. But I would ask for the opportunity to, I'll turn him in as soon as I locate him, if the court issues a capias.
Yeah, I'm going to issue a capias. It's the exam date. And it's 9:15, 9:20. People are ready to move forward. Attorney Carson, if he was here, I would have given you an adjournment based off of your circumstances.
Thank you.
It's going to be personal 1,000.
Thank you, Your Honor.
Welcome and best of luck to your family and your dad.
I appreciate that. Thank you.
Have a good weekend.
You too.
Thank you. That's not even it. That's just on deck. Okay. Attorney Walmore,
Yes, Your Honor.
I see your camera's turned on. Are you ready for me to call your client's case?
Yes.
Okay. Okay, this is the people of the state of Michigan versus Lamar Eugene Williams. Case number 2055, 20566610. Mr. Williams is charged with count 1, stolen property, receiving and concealing a motor vehicle, second or subsequent offense notice. Count 2, motor vehicle, unlawful driving away with a habitual offender, fourth offense notice. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Kenneth Waldhorn on behalf of Mr. Williams, P37819.
Okay, good morning, and Attorney Walhorn, you have attempted to try to communicate with your client, is that correct?
Numerous times over the past couple of years, actually, but most recently, several different phone numbers. The most recent appointment form, and one identified by way of voice on the voicemail as Lamar. So I think I've had contact. Well, I think I've made contact with, but have not heard anything back. Ultimately, I was going to ask the court to set this for an exam. He apparently appeared last time a week or two ago late. And I don't know whether the court would be interested in very tentatively setting an exam date should he appear.
So I spoke to him directly on February 24th. They told him to be here promptly at 8:30 a.m. today on March 3rd. So since you are asking Attorney Waldhorn, I will set an exam date. And of course, if he doesn't show up, there will be a capious entry, and it will be $5,000 cash, won't be the $1,000.
Understood.
Okay, so I'm going to set an exam date, let's see. Rather early. My computer is frozen. Give me an exam date. What is put in March? Yeah, we have March 9th and 11th. Okay, how about March 9th at 11:30?
That is not a good day.
Okay. March 10th, 11:30?
That's a much better day.
Okay,
11:30.
yes.
Now, I would hope the court would reach out to me if Mr. Williams appears. Otherwise, the court's indicated it will issue a, at some point, I guess, in the morning, a capious.
Yes, and we will contact you. I believe, if I remember correctly, I gave him your contact information to call you on the 24th.
Oh, we can only do so much.
That's right. We'll see what happens on the 10th.
Thank you.
You are welcome. You have a good rest of your day and weekend.
Stay safe, everyone.
You too.
Take care. Bye.
Bye-bye. Attorney DiMaggio, good morning. I think I have you muted.
Good morning, Judge.
There we go. How are you today? Mr. Watkins is here. Do you need to speak to him?
No, unfortunately, Judge, there's been a breakdown in the attorney-client relationship. I would request to be taken off this case.
Okay. Mr. Watkins, go ahead and unmute your device.
Is unmuted.
Is that accurate or pretty correct, Mr. Watkins?
Yes.
Okay. We're gonna call over and get you another attorney.
Okay.
All right, Attorney DiMaggio, we'll call over third circuit to get to another appointed attorney.
Okay, thank you, Your Honor. Yep.
Okay, Mr. Watkins, so the process, how that works is there'll be an attorney that zooms on in about 10 minutes or so that will be your new attorney. I'll put you in a breakout room. You can talk to he or she about your case, and then we're gonna go on the record and get you an exam date and possibly another probable cause conference, depending on your discussion with your attorney, okay?
Okay.
So just hold tight. I'm gonna put you in the breakout room now. You'll be in there by yourself. Your attorney will come shortly.
Okay.
So go ahead and hit join on your screen. I have. Aliyah, Bernard, Schmidt,
Robert, it's him in the meeting. You gotta dial it from your phone, the same way I dialed it.
Ma'am, we are in court right now. We can hear you. Can you please stop yelling?
Okay. I'm calling for my boyfriend. He's unable to get in the meeting. Hello?
We're on the record as the people of the state of Michigan versus David Bradley. Case 225-6087. Mr. Bradley is charged in this case with count 1, breaking, entering a vehicle to steal property, $1,000 or more, but less than $20,000. With an habitual offender 4 offense notice. Mr. Bradley is also charged in case 2355450 with the following counts: 1, 2, and 3 of police officer assaulting, resisting, and obstructing with offender 4 offense notice. Today is the day set for a preliminary examination on both cases, appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, 85495.
And there's no defense counsel present for the defendant. That's correct, Ms. Parrish, have you?
Yes, Your Honor, that is correct. The defense counsel is not present.
And the counsel is not called the court. The court did try to contact counsel and left the voicemail to no avail. Mr. Bradley's first exam was scheduled for 9 o'clock. His second exam was scheduled for 9:30. Are the people ready to proceed today?
Yes, Your Honor. On both cases, we have our necessary witnesses available and here outside the court, ready to testify. And the people would ask for a habeas on both these cases at this time due to the fact that the defendant has failed to appear.
Okay, and I reduced Mr. Bradley's bond and let him out on a personal $1,000 bond with a tether, and he's not showing up today. And on case ending in 87, has a failure to appear history. So I am going to issue a capias, and it'll be for $3,000 cash on both cases. And we will deal with that matter if he's ever found. We're on the record.
Thank you, Your Honor.
That was my fault.
Fisher?
Nope, that's next case. Thank you. Good morning again.
Good morning again. Didn't know I'd be back in here.
I'm sorry, what'd you say?
I said I didn't know I'd be back in here.
I didn't know either. I have Mr. Watkins in the breakout room. You ready to talk to him?
Sure, that's fine.
Do you know, except for, do you have any details about his case?
I just got a CCW and that he's the only person on the matter. That's the only thing trial court services told me.
Okay, yeah, and it's up for a PCC today.
Yep.
Okay, let me put you. Try to call Fisher. So. Look odd, but I did notice it's no attorney assistant. Oh, yeah, I had that on my screen. I may have found it out.
Your Honor, I think Mr. Watkins accidentally left the breakout room and left the whole meeting in itself.
Yeah, I see that. Once I'm sure he'll, if there he is, okay. I'll put him back in there.
Thank you. Appreciate it.
Excuse me. Oh, all right, I'm back.
Yep, I'm gonna put you back in the room, Mr. Watkins.
Okay.
You know what I mean? Yeah.
Yeah. Attorney Roberts, welcome back.
Good morning. Thank you for your patience. Sorry, I was finishing up an AOI.
I didn't know you were on this case as well.
Yes, it is a, oh, sorry, Your Honor.
He hasn't shown up.
This is first time. I don't know that we have a good contact number for him. Does Madam Clerk have a good number that I can reach out to?
I'll check. I have the file. Let me see.
Thank you.
I have 313-742-9419. Oh, you're on mute, Attorney Roberts.
Oh, thank you. I will give him a call right now. Thank you.
Okay.
Yeah.
Thank you for your patience. I would ask at this time if we could set the case or call the case, I should say. We would probably need another week before doing some type of capious review date. I just want to make sure we can send out additional letters and see if we can find some alternative phone numbers for Mr. Fisher.
Okay, Attorney Roberts, right now, I'm inclining to capious or set it for an exam date. And because I guess it's on the record, as long as you have discovery, I'm ready to set it for an exam date because I am experiencing a high level of capious with defendants. I was giving them a little bit too much leeway. I'm understanding that it's really clogging up our time. So let me just call the case and we'll get into that. This is the people of the state of Michigan versus Jamar Thaddeus Fisher, 2355333. Mr. Fisher is charged with count 1, police officer assaulting, resisting, and or obstructing, and count 2, retail fraud, 3rd degree, which is misdemeanor. Today's date set for a probable cause conference appearances.
Good morning, Your Honor. Danielle Parrish on behalf of people P85495.
And good morning, Your Honor, court staff, Jonathan Roberts, P86438, on behalf of Mr. Fisher. For the purposes of today's hearing, just requesting that his presence be waived.
Okay, I will waive his presence. Ms. Parrish, have you provided discovery?
Yes, Your Honor. Paper discovery was sent on the 20th of February and digital discovery was sent on March 1st to NDS's general discovery.
I do have the paper discovery. I will follow up with our team administrator to check on the digital. But I trust Ms. Parrish has sent it. We'll just need to find it in our logs. If that's the case, we can set this for an exam, and that would at least give our office enough time to also reach out to Mr. Fisher and do those necessary contacts on it.
Okay. Let's see here.
And I do believe I'll be in front of Your Honor. Did we say the 10th? Was that the day that we?
Oh, yes, you have 2 other cases, right?
Yes.
Oh, yeah, yeah. I can schedule, we can schedule it for 8:30 for both. And
Okay.
handle them, whoever comes first, handle it that way.
Thank you, Your Honor.
Okay, so March 10th at 8:30.
And Ms. Parrish, I'll follow up if there are any outstanding discovery issues, but thank you for sending the discovery.
Not a problem. Feel free to reach out to me this afternoon if you feel something is missing in the package that was sent, okay?
Thank you.
Thank you.
All right, have a good weekend, Mr. Robert.
You as well. Thank you.
Okay. Reschedule. Yeah. It's 9:51. We're good. Okay, ready on Watkins?
Yes, Your Honor.
Okay, this is the people of the state of Michigan versus Martell Ronio Watkins, 2355264. Mr. Watkins is charged with 1 count of weapons carrying concealed, set for a probable cause conference. Appearances.
Good morning, Your Honor. Danielle Parrish on behalf of people P85495.
And good morning, I'm Mohammed Seba, P 83365 on behalf of Mr. Watkins. Mr. Watkins, may you please present yourself to court?
Mr. Watkins speaking. Good morning, Your Honor.
Good morning. Did you say your first name?
Martell Watkins.
Thank you. Good morning. Okay, did you have an opportunity to speak to Mr. Watkins about his case?
Yes, Your Honor, and I would like to receive discovery on this matter just so I can go through it with the client, with my client. I feel at this time I wouldn't be able to adequately represent him without it.
If defense counsel wouldn't mind to give me his email, I can have it to him this morning. We have,
Sure, would you like me to speak it, put it in the chat? Or-
yes, because we have both,
You can put it in the
paper
chat.
and digital on that one, I think.
You can put it in the chat and I'll give it to you.
I'll put it in the chat. Thank you.
Okay, I have it. One week enough time?
That's enough time, Your Honor. I'm in here next Friday as well, so.
Okay, so that'll be the 10th as well. We got a long day of the 10th. Okay.
Yeah.
All right, so let's set it for 8:45 on the 10th for another PCC. Go from there.
Thank you. Mr. Watkins, I'll call you. Thank you.
All right, thank you.
Thank you, Your
All
Honor.
right. Good weekend.
You too, bye.
No Attorney Anderson? No Attorney Anderson?
Record, right? Say it out loud.
Okay. We are on the record. This is People's Transmission versus Manson Manfred. 2161019. Ms. Manson is charged with count one, assault intended to rape Valley Farm lesson by strangulation. Count two, assault with dangerous weapon, felonious assault, and count three, aggravated misdemeanor. Today is the day set for a preliminary examination appearances.
Good morning, Honor Danielle, appears on behalf of the people, P 85495.
And good morning, Your Honor, Neighborhood Defender Service by Lauren Anderson, P 85191, on behalf of Samantha Manson, who's currently in court.
Ms. Manson, please state your full name for the record, please.
Samantha Laurie Manson.
Good morning.
Good morning.
Are people ready to proceed?
Your Honor, my apologies. The people, necessary witness, complaining witness has failed to appear. I would like to put on the record that, the people and myself personally, attempted to, contact the complaining witness yesterday multiple times. Their phone was having I didn't recognize the type of, outgoing message, but essentially that it was not taking calls. Also, I reached out to the OIC multiple times. I even called the precinct. I was informed that the OIC has changed locations. I left a message for their supervisor to confirm that the subpoenas, as the subpoenas were emailed to not only the OIC, but their supervisors. But I did not get back. Nobody actually returned my call, Your Honor, not the complaining witness, not the OIC, not the supervisor of the OIC. At this time, none of the witnesses have, or the main witness has failed to appear at this time.
So you've done your part.
I tried, Your Honor.
Okay, anything for Benson?
Your Honor, at this time we move to this.
Okay. It's 10:15, exam is scheduled for 10 o'clock. Complaining witness is not present to move forward. Therefore, the people are not. So I will dismiss without questions.
Thank you.
This one's done, right? I don't know why. You know, that's the PCC 310, yeah. 10:30.
It's gonna be instead 6.
Oh, wow, you're right. So you should have it.
Right?
Okay.
Everybody.
I'm trying to be quick. Yeah.
Stay safe. Have a great day.
Thank you. Any word on Thomas?
No, ma'am. On
person on a Samsung SM device, state your name.
David Bradley.
So I place you in the waiting room until the judge comes back in the courtroom. Yes.
Something on Stevenson, maybe I missed it.
Stevenson, exam for March.
PCC at 8:30.
Yeah, March 10th, exam at 8:30.
March 10th is the preliminary exam.
Yes.
At what time?
8:30.
On Stevenson.
Yes. Oh, no problem.
And Clark, I heard you right when you said it's a preliminary exam, right? It wasn't an adjourned PCC like the other one?
Here, let's double check what she wrote, but I'm pretty certain that's what it was. I'll double check.
That's the one where the same. Maybe.
Yeah, exam at 3:10, 8:30. No problem.
Thank you, I heard myself.
This is a recall for David Bradley, case number 2256087, as well as 2355450 appearances.
Daniela Parrish on behalf of the people, P 85495.
Police attorney from the Neighborhood Defender Service of Detroit, P 83960 on behalf of Mr. Bradley, who is hereby assumed.
I'll read the name. Are you Mr. Bradley?
Yes, ma'am.
Can you say your name for the record, please?
1 second.
State your name for the record.
David Patrick Bradley.
Thank you. Okay, so I will summarize what's happened this morning. Mr. Bradley had an exam scheduled for 9 o'clock and 9:30. The clerk attempted to contact defense counsel. No success. Mr. Bradley did not appear in person nor on Zoom. And I called the case, I believe, at 9:45. No. Yeah, somewhere right between 9:45 and 10 o'clock. And entered his capious at $3,000 cash, and now counsel is present in person with Mr. Bradley on Zoom at the request of the defense counsel to recall the matter.
Thank you, Judge. Requested court to watch the KPS that was issued earlier regarding not entered into lien. Mr. Bradley, I was under the impression Mr. Bradley was in custody. Mr. Bradley has 5 separate cases presently, and following this court setting a personal bond, he appeared in front of Third Circuit Judge Bridget Hathaway, who maintained his bond at a $20,000 cash bond. Mr. Bradley recently posted that bond and was subject to GPS monitoring. I discovered that this morning, and my colleague informed me that this court had called the case. I was able to reach out to Mr. Bradley's sister and find out his new phone number and get a hold of Mr. Bradley, which I did not have. He is in compliance with electronic monitoring conditions, and his failure to appear this morning was not willful. Because
his failure to appear was what?
Was not willful this morning. My typical practice when I have a client that is out on release is to, make sure they're aware of the next court date and that they will have that available by those reminders. I did not do that for Mr. Bradley because I was under the impression he was in custody. Mr. Bradley currently has a preliminary exam set in this court on the 8th of March next week. When I spoke with Mr. Bradley this morning, his honest belief was that he was set to come down on the 8th in front of Judge King. He also had two matters set before the Third Circuit Court on March 10th that is happening as well. Mr. Bradley was provided with no information by the Wayne County Jail upon his discharge, and his confusion with the dates, I think, was an honest mistake that he made. He was his sister who got a hold of him. He was honestly surprised to hear it and being surprised in his voice that he had court this morning. And I asked him to come down. In addition, I appeared by Zoom this morning at 8:45. I was from the Zoom room. I wasn't able to join the court that at 7. I was scheduled for Third Circuit Court this morning, and I'll be late for the preliminary examinations this morning.
Did you announce yourself?
I did, but the court removed me at approximately 8:48 a.m. And when I went to rejoin the Zoom meeting, it said that I was unable to rejoin because I couldn't move the meeting.
You identified yourself?
One of the court officers indicated that there was a unruly individual in the Zoom room this morning, and the court removed, or the host removed a number of people from the Zoom room as a result. And when you get kicked out of Zoom, you can't rejoin because someone gets removed. It's for that exact reason, so that someone can't repeatedly harass folks.
I don't know how to do that.
Well, whoever was hosting the Zoom meeting.
I'm the host, so I don't even know how to watch.
Well, I was removed from the meeting at 8:48, and I was unable to read.
Your Honor, if I may, to people,
One second.
course of defense.
One moment. I don't recall you zooming in and saying you're here for attorney Mr. Bradley. Okay, what were you saying, or I don't recall you. maybe you did, but I don't even know how to block you, so.
Yeah, I think the act of removing somebody from the room functionally blocks them, it keeps them from coming back.
No, they keep coming back.
Well,
I don't have.
when I log back in, it wouldn't. So I was driving down Woodward in my car and I looked down and I said, I'm surprised by that. So, and I did see the court attempted to call me twice. I was on the record in front of Judge John Gillis at the time, for a sentencing. And then by the time I got done with that sentencing, I was more concerned. So, given all of that, Judge, I would request the court, watch the KPS, or to have that yet. Ms. Bradley's already back before this court on the 8th in front of Judge King. I don't support any availability that I don't know if it's relatively close to
Sharon, I understand the situation with defense, and I believe that that is excusable. However, it doesn't excuse the fact that the defendant did not appear. And the defendant was aware of the date, and I understand the defendant apparently has multiple cases, and it's hard to keep track when you have a lot of cases. Okay, but that's not for defense counsel to have to. He's not a child. He doesn't have to baby him and bring him here personally, or have to call him up to remind him when he has court. I believe this court actually gave him a personal bond and believing that he would be here, so he was aware of the date. Also, he has KPS history. So the people would request that the personal bond be revoked and that he actually have to place a bond because he failed to appear today. We had all of our witnesses here on both cases, and it wasn't a one witness case for each one, there were multiple, at least 3 on each case. And we now have to reschedule, and the 8th, even if it's available with the court, is likely not available because we have to get these people back out and resubpoena them all. So we need at minimum 7 days to get them back here. And the cost, the effort, the time put into this, I believe, and the fact that this is not the first time the defendant has had a KPS, we believe that there should be something to force him to make sure that he is here next time, and that being a bond, if not the exact bond that you had stated earlier when he did KPS, some sort of bond as opposed to a personal bond, so that he does come here and the defense doesn't have to actually go searching for him to make sure that he gets here.
Well, Mr. Bradley has on page 87, stated to appear on March 22nd, 2022. He failed to appear on June 7th, 2022. Failed to appear on August 9th, 2022. And failed to appear on time today for 9 and 9:30. We scheduled these cases so that we can move along. I specifically scheduled 9 and 9:30 so Mr. Bradley can have time to hold both exams. I don't know if Mr. Bradley, I don't know what his thought is on the courts and our ability and our willingness and to revolve our day around him and his time and how he has to manage his day in cases. But it's gotten to the point, not with just Mr. Bradley, with other defendants. I put him out, I gave him a personal bond with tether in consideration of the request based off of his needs and his, even though he had a failure to appear history. But today he has demonstrated once again that he just does not find this to be a serious matter to come to court. Both cases. And all of the complaining witnesses were present today. We could have scheduled someone else's cases today and handled theirs within the 5 to 7 days that we've been trying to schedule plenary exams, that people can have their exams scheduled statutorily how they're supposed to be. So it just wasted an hour and a half of our day. And I don't have anything available on March 8th or March 9th, whatever day that was. Mr. Bradley, I'm pretty much tired of this failure to appear history that I've seen in your case. You should know better.
I understand, but I've got a lot of mental issues.
Did you receive notice of today's court date?
I didn't get no paperwork when I was in the county jail, so when I left, they didn't put this on there as one of the court dates, so I thought it was on the 8th.
We cannot do that, so, I will give you the next available date. Plus, I don't want to be waiting for him to finish his other exam downstairs with Judge Key. March 16th at 10:30.
I'm available that day. I currently have no other court schedule.
Mr. Bradley,
Ma'am.
March 16th at 10:30 for both cases.
Both cases.
Yes.
I don't even know what cases we're talking about. I'm lost, you know.
You're gonna have to talk to your attorney about that.
I've been trying to get a hold of him for about 3-4 days now. I just didn't know his number.
Okay, well, we're gonna make sure that you have his number today.
Thank you.
So since the warrant has not been issued into the system, I would call the warrant and keep on as is.
Thank you, Judge.
I will log off YouTube if you need me to, so you can provide a phone number to your client.
We've been texting back and forth this morning, so we have.
So Mr. Bradley, you have his contact information. You call him to get more clarification on which cases you need to be here for today or for present for on March 16th. Okay?
Okay.
Anything else?
The 16th, was there a time, sir?
10 o'clock. I think that's it. So let me make sure.
I'm sorry.
10:30. I don't want any confusion. 10:30
Oh, thank you, Judge.
for both cases. Mr. Bradley, you can log off. I will see you on the 16th at 10:30 in person sharp.
Okay.
All right. Ready on time?
Yes.
Calling case 2260955, the people of the state of Michigan versus Darrell Jerome Thomas. Mr. Thomas is charged with count 2, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 3, weapons, firearms, possession by a felon. Count 4, count 5, both weapons from firearms with an individual written report offense notice are Mr. Thomas, and Mr. Thomas is defendant number 2 on this matter. They will get set for a preliminary examination appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for people. And good morning, Your Honor. Good morning to your staff, Neighborhood Defender Services by Kim Williams, PA 2125, on behalf of Mr. Darrell Thomas, who is here behind me to my right.
Mr. Thomas, please state your full name for the record.
Darrell Jerome Thomas, Jr.
Good morning to everyone.
Good morning.
Preliminary matters.
Yes, Your Honor. The people admitted to evidence a certified copy of prior felony convictions under 7611B1B. I'm showing it to defense counsel right now.
The objection.
Objection, Your Honor. The people move to publish this as state as exhibit 1.
Be admitted.
Thank you. Also, Your Honor, the people also move to admit the preliminary drug analysis under MCL 7611B1A as exhibit 2. Showing it to defense counsel.
Any objection?
No objection. This is exhibit 2 now, Your Honor. We were ready to call our first witness.
I'll admit that is exhibit 2.
Exhibit 2.
And I will, there's no officer in charge on this case that we're sitting in, correct?
The officer in charge is going to testify, so he's going to be in the hallway.
Okay. If there's anyone on YouTube listening now who may testify on this case, now is your time to log on. With that, Mr. Jeffrey, you call your first witness.
The people call Corporal John Talbert.
I do. Okay, have a seat and make sure you speak up at the microphone.
Okay, good morning. Please restate your name for the record.
John Talbert.
Are you currently employed?
Yes,
Where are you currently employed?
City of Detroit Narcotics Unit.
Okay, so, how long have you been there?
Been on the job 28 years.
Okay, so does that mean that, you were employed in this capacity on December 13th of 2022?
Yes,
Okay, so, so what kind of, duties do you perform for the Detroit Police Department?
I investigate quality of life crimes for the city of Detroit.
Okay.
Narcotics, and all that entails.
Okay, so what does that mean that you do sometimes?
I'm a narcotics officer. I investigate narcotic sales
Okay.
and possession.
Do you ever execute search warrants?
Yes, I do.
Okay. Now, did your duties as a police officer take you to 14819 Terry Street in the city of Detroit and County of Wayne?
Yes, it did.
Does that sound like a familiar address to you?
Yes,
Why does that sound familiar to you?
executed a narcotic search warrant at that location.
Okay, so now let's just go back to that day on December 13th of 2022. What happened when you arrived on the scene?
Arrived on the scene, purpose and presence was announced.
If I may, this is my mistake. Let me go back a little bit. What were you wearing that day? Were you in full or modified uniform?
Full raid uniform.
Full raid uniform, what does that entail?
Shirt, pants, marking, police, raid, narcotics patch, helmet, raid vest, firearm rifle.
Okay, now were you alone or did you have a partner?
With the whole crew.
Okay. So, how many people would you say were on the crew that day?
Approximately 8.
8?
Probably more.
Okay, what name, do you remember some of the names?
Officer Levy, Officer Nelson, Officer Kelsey, Sergeant Briggs.
Okay.
Keep going.
Okay, it's okay. All right, so let's just go right to, what did you do when you arrived on the scene?
I was number 2 in the stack. I was number 2 in entry rifle position. Once inside the location, several subjects found inside. We cleared the rooms and found somebody hiding in the closet.
Okay. When you got into the room, you said you saw some individuals, but did you see anything else? Like objects?
Not right away.
Okay. If not, okay. So you mentioned there's someone in the closet. What happened next after you saw a person in the closet?
The Officer Levy, ordered that subject out of the closet, passed me, which I passed him on to the rest team.
Okay. Now, is it possible?
Sorry, you said pass on, I didn't hear what you said.
Yes, I passed him on to the rest team. handcuffed.
Okay, thank you.
Now, you said there was someone in the closet. Is it possible that you recognize that person in the courtroom today?
Yes, I believe it's, the gentleman sitting in the first row, mask on, gray jacket.
Okay. Let the record reflect that the officer has identified the defendants.
Your Honor, I would object. I think what he said is he believes. Does he know this is the person he arrested, or does he not know this is the person he arrested?
Could you have him take his mask off, sir?
Can everyone take your mask off for 10 seconds?
Yes, that's Mr. Thomas, who's hiding in the closet.
So, sorry, but
Okay, thank you, Your Honor. Let me see here. So you sent him to be, I'm sorry, you sent him to the arrest team, is that what you said?
Yes,
Okay, what does that mean? What happens then?
he was detained and placed in a secure area.
Okay. So, then after that, what did you do?
They finished clearing the location. I stood by with the detainee while the location was cleared.
Okay, so then after everything was cleared, what'd you do?
I assisted with the search of the location.
Okay, so, where did you search?
I searched the closet area where Mr. Thomas was found hiding. And I subsequently searched another room.
Okay.
Next to that one.
All right, well, let's start with the closet. Did you find anything?
Yes, I found a black bag. That,
What kind of bag?
It's like a man bag or it's a satchel bag.
Okay, so you found the bag, then what'd you do?
Searched the bag and found the firearm inside.
Firearm, what kind of firearm?
It was a tan, the yellow cat, 9mm.
Okay, anything else in the bag?
Mr. Thomas's ID.
Okay. All right, so you said you searched another room. Did you find anything else?
Yes, I found one Ziploc crack cocaine.
Okay. What, if anything else?
I found another container containing suspected crack cocaine on it.
Okay. And any other narcotics found?
It was a plate that had narcotics on it also.
Okay. Well, you say narcotics, what made you think there were narcotics on the plate?
It was a white lumpy substance, indicative to crack cocaine.
okay, white, what's up?
Lumpy substance.
Okay. Once you found the narcotics, what did you do with them?
Later, they were conveyed to PPU and placed on a live seal folder number and evidence.
Okay, do you possibly remember that lock seal number?
Refreshing my memory from my report.
Oh, yes. Would you like me to bring you your report?
Aye.
Oh, you have it? Okay. Is that, Your Honor, may he use that to refresh his recollection?
As long as the defense counsel and prosecutor or Mr. Deputy can see that it's important.
Let me make sure.
I have the last sheet.
Oh, the last sheet. Okay, yeah. Defense counsel, is that? No. He said no objection.
Oh.
Okay. So yeah, go, let us know what that lock seal number is, please.
Now it's gonna be N05747-849. One sandwich bag containing cocaine, 0.1 grams.
Let the record reflect it also that is on People's Exhibit 2. All right, and then after that, what did you do?
We all left the location and went back to PPU and finished our reports.
Okay, nothing further.
Good morning, Officer Thomas. Charles Patel.
Good morning, sir.
Just a few questions for you. You said that you were part of a raid team, correct?
Yes.
And this raid team was 8 members, correct?
Yes.
And approximately, we're at about 7:35, you may be seen.
5:10, I believe.
So. So you made scene with your team, you organized, correct?
Say again, sir?
You made the scene with your team, correct?
Yes,
And you organized outside, correct?
yes,
At that time, did you see anyone enter or leave the residence?
no,
Okay, and so you prepared to enter, and you announced presence and purpose, correct?
yes.
And approximately how long after you announced presence and purpose did you make entry?
5 to 6 seconds.
Okay, so you yell, police, search warrant, correct?
No, the breach officers knock on the door with the Halligan, say please. They wait for the order from the sergeant to force the door.
Okay, so 5 to 6 seconds passes, correct?
Yes,
And at that point, you breach the door,
yes,
correct? When you breached the door, there were several occupants in the house, correct?
yes,
In addition to my client who was in the house, there was a Jerome Donovan, correct?
yes,
There was also a Mr. Ennis Moss, correct?
I'm not sure of anyone else's name, but Mr. Donovan is.
Well, is it safe to say there were several people?
Yes, sir.
Correct. In fact, my count, there were 6 other people in the house, correct?
Yes,
When you entered the house, were people standing still?
no, they weren't.
They were scattering, right?
Correct.
They were running all over the place. Correct?
Yes,
They were hiding, correct?
yes,
So it's fair to say that you're not sure where anybody was prior to you entering that house, correct?
prior to me entering, yes, correct.
So you found people, correct?
Yes,
You just don't know where they were before you found them, correct?
yes,
And you didn't find anything on my client, correct?
no, I did not.
Okay. Just one, you know. No further questions, John.
Just one, was the defendant the only person that was in the closet?
Yes.
Nothing further.
Any other witnesses?
Yes, Your Honor. The people call Jalen Williams. Good afternoon. Please restate your name for the record.
Good afternoon, Officer Jalen Williams,
All right, where are you currently employed and in what capacity?
Detroit Police Department Narcotics Section.
How long have you been with the Detroit Police Department?
6.5 years.
Okay, now are you the officer in charge in this investigation of this case?
I am not the officer in charge.
Okay. So what did you do with this case?
I was a part of the execution raid crew, narcotics crew.
Okay, so when you say that, hold on a second. So you say that was at 4819 Terry Street in the city of Detroit and County Wayne?
Yes.
Okay, so you were part of that. Now, let me ask you this. In the course of your investigation in this case, did you have the opportunity to speak with the arrestee in this investigation?
Yes.
Okay. Would you recognize him if you saw him today?
Yes.
All right. Do you see that? If you see that person in court, maybe tell me something they're wearing. Point them out for me, please.
Blue medical mask, gray jacket, first bench.
Okay.
Behind you.
Let the record reflect, Your Honor, that the officer has identified the defendant. Okay. Now, when you spoke with the defendant prior to speaking to the defendant, did you have the occasion to advise the defendant on his constitutional rights?
Yes.
As known as Miranda warning?
Yes.
Okay. How was the suspect advised of his rights?
Verbally and he read them.
Okay. Was there a form?
Yes.
Okay. Did the defendant appear to understand your questions regarding his rights?
Yes.
Did the defendant invoke his right to remain silent or have an attorney?
No.
Okay. Your Honor, may I approach with People's Proposed Exhibit 3? Okay. There's no touch screen there. Oh. Okay. Does that appear to be a fair and accurate copy of the advice of rights form in this case?
Yes.
The defendant initial next to each right indicating that he understands, including any statement will be used against him in the court of law?
Yes.
Okay. How was the defendant's physical appearance when he signed the form?
He was well.
Okay. Was his speech coherent?
Yes.
Did he appear to be intoxicated at all?
No.
Your Honor, permission to publish to the court?
To admit or
Publish. Pardon me?
to admit it?
Yes, to admit it.
The objection.
And I'd like to ask a question, finish some questions as to the voluntariness of the statement.
Oh, one here.
Sure.
Officer Williams, you interrogate my client roughly 90 minutes after the rape.
We can say yes. It wasn't right away. It was later on.
Right. And you weren't the one that originally apprehended, right?
No.
Okay. You heard that there was cocaine in the room, correct?
Yes.
All right. Did you ask my client, had he used any cocaine?
I can't recall.
Okay. So you don't know that you found did you see cocaine that was on a block, I believe? On a slab?
I did not.
Okay. Looked like it was ready to be used.
I didn't see it.
Or could have been used, correct?
It could have been used. I didn't see it. I don't say I didn't see it.
So you don't know if my client had taken any intoxicating drug, right?
No.
The best you can say is that he looked, I believe you said, well, is what you said?
What I was saying is he looked fine to me, if that makes more sense.
You look fine, but you don't know, correct?
No.
If he was under influence.
No.
Yeah, I think I'm going to object to the statement being entered. We don't know when the client and the officer did not inquire whether or not my client was under the influence of any drugs at the time of the statement.
Judge, you have a response?
Your Honor, I'm looking through this. Well, the officer says that he didn't necessarily see that he was under any kind of influence of drugs in his personal observation, and the fact that he's been a police officer as long as he has, the fact that he has been that he does this kind of thing quite often. It seems like in his knowledge and experience, he'd be very well qualified to decide whether or not someone is under the influence of drugs. So it doesn't seem to me like if still looking to see if he, so it just seems to me like his testimony was given and it sounds honest and qualified to me.
And yeah, I don't believe one of his expertise is the effect of cocaine or narcotics on a human, I believe he's a law enforcement officer. I think what his primary purpose was to gather a statement and not necessarily tell whether or not my client was under the influence of any of the drugs that they found in the house.
Okay, well, the requirement is not for officer to drug test and see. Based on his testimony, he's saying that he appeared to understand his rights. He verbally gave him his rights. He read them to him and the defendant read his rights. His speech was coherent. He did not appear to be drunk or under the influence, and that he looked fine and looked well. So I do believe that his statement based off of that is voluntary. And you were asking to have it admitted, correct?
Pardon me?
You were asking to have people's proposed exhibit 3 admitted.
Yes.
I will admit it.
Okay.
Over defense counsel's objection.
Thank you. And is, well, it's the.
I'm sorry, the advice of rights form.
This advice of rights form was 3, and foreshadowing, we're about to introduce 4. Is one here. Okay, cool. All right, so would you recognize the Q&A for the Q&A written statement if you saw it today?
Yes.
Okay. It's not a touch screen, you have to. Okay. What have I just handed you?
Just handed me the interrogation form, right?
Okay, so you recognize that?
Yes.
All right, does that appear to be a fair and accurate copy of the Q&A statement?
Yes.
By the defendants?
Yes.
Okay. That's the defendant Darrell Thomas?
Yes.
I don't know if I said that earlier, but okay. Does that, okay, so does it appear to have been altered in any way?
No.
Okay, Your Honor, do people move to admit people's proposed exhibit 4, which is the Q&A statement and evidence, please?
No objection.
Okay, now turning to the first page of the exhibit, could you read the questions and answers for us, please?
Question 1, did you understand your rights? Answer is yes. Question 2, on December 13, 2022, around 4:10 p.m., were you located at 14819 Terry? Answer, yes. Question 3, did you have contact with Detroit Police Department? Answer, yes. Question 4, where are you located inside of the house? Answer, in the back room. Question 5, which room in the back are you referring to? Answer, the room in the back to the right. Continuing, question 6, were you inside of the closet? Answer, yes, sir. Question 7, do you own a black handbag that possess your ID? Answer, no. Next question, continue. Were you aware cocaine was inside of the room you were detained in? Answer is yes. Continue, next question, were you aware cocaine was inside the location? Answer is yes. Continue, next question, were you aware heroin was inside the location? Answer is no. Next question, where was the coat located inside the room you were in? Answer, on top of the bed. Next question, do you sell narcotics for hustle? Answer, yes. Next question, what do you sell? Answer, cocaine. Next question, how much cocaine do you sell? Answer, not a lot, maybe a gram. I smoke the rest. Next question, were you aware of any guns being inside the location? No. Final question, were you forced to make any statement? Answer is no.
Your Honor, permission to publish to the court. As in the, no, as in the,
Yes.
Okay. All right, nothing further.
Officer Williams, so you took the statement from my client, correct?
Yes.
You believe my client would be honest when you make the answer, correct?
Yes.
Okay. And my client, at admitted to certain things freely, correct?
Yes.
He didn't need coerce to make any statements, or he didn't appear to having difficulties giving you those answers, correct?
Yes. Well, he didn't feel like, I'm sorry, can you restate that question? Well, I can answer it correctly.
My client answered freely.
Uh-huh.
He didn't seem to be forced when he made any answer.
No, he was not.
He wasn't confused when he made any answer, or it appeared to be.
Did not. I'm sorry, he did not appear.
Okay. Now, in the statement, my client admits to being aware that there was cocaine in the house, correct?
Correct.
My client also admits that he had sold cocaine, correct?
Yes.
But you didn't ask him, was he selling cocaine at the time, correct?
No, I did not.
Okay. My client did not admit to owning the bag that the gun was found, correct?
Correct.
My client did not admit to being aware that there was a gun in the house, correct?
Correct.
Nothing further, Your Honor.
Nothing further, Your Honor. No, Your Honor.
I'll wait till.
Your Honor, the people, believe, the people are public, the people motion for bind over the Third Circuit Court. The question of fact has been established and is, can be presented in front of the trier of fact, and we reserve time for argument.
Yeah, we're going to object to the bond over of the information or the warrant in this case. I believe Officer Talbert testified that they did a presence and purpose, and in 6 seconds, they reached the door. People were running, he testified that people were running all through the house. There is no way to determine where people were when things started, or all he can determine is where he found them. The fact that he found my client in a closet where there happened to be drugs in the house does not necessarily mean that he started that position there, or he is responsible or had knowledge of anything in that room. Your Honor, Officer Williams testified that he believed my client was being honest, forthright, did not have any difficulty answering his questions. He answered questions that obviously would make him liable under the law for certain crimes. He answered that he had sold drugs, but he did not answer say that on the day that this warrant was being executed, that he had anything to do with drugs being sold that day. He said that I have sold drugs. He admitted that. He admitted to knowing where the drugs were in the house, but he didn't admit that he sold drugs. And more importantly, he did not say while he was admitting everything that he knew anything about this bag. He didn't know who the owner of the bag was. He did not know where the gun was for. He did not admit that he knew there was a gun in the house. Yeah, I don't think we have enough here. Therefore, I'm going to object to the bond.
Your Honor, the testimony revealed that the defendant was in a closet, and in that closet, he had a bag. That bag had an ID in it, and it was the defendant's ID. That would then lead us to believe that the bag that he was in the closet with by himself would be entirely his, and would then therefore say that there's a question of fact for the trier of fact when it comes to the felon in possession charge. As for the drugs, yes, he was in the house. He was, but of course, when he spoke to the officers afterwards, he specifically said that he was aware that there was cocaine in the house. He freely confessed to the fact that he does sell the cocaine. At a minimum, it seems in the preliminary exam stage that means that the case is ready, and the probable cause has been established. The trier of fact is the next person that needs to hear this case. Thank you.
Mr. Decker, I know you published it to the court. Can I see the statement?
The statement?
Or-
Yeah, unfortunately, yeah. Yeah, because I just have it on my computer, so.
Yeah, I have a couple.
Oh, you have a paper copy? Okay, thank you. Yeah, I have it.
Okay, for her testimony from Corporal John Talbert as well as Officer Jalen Williams. I'll deal with the gun first. Their testimony that once the raid team entered the house and searched for what they call bodies, the defendant was found in a closet with a backpack in which a black bag, I should say, excuse me, that backpack. And the officer described it as a man bag or satchel. In that was a tan Hellcat 9mm firearm with Mr. Thomas's ID. For that count and any accompanying accounts, felony firearm, felony possession, I do believe that people have met in burden of proof, as that is enough to show possession and knowledge or ability to control with knowledge, seeing that Mr. Thomas's ID was in the bag with the gun in the closet, and he was the only individual in the closet. As far as the drugs, this one is a little, it's not as, I should say, easy to determine. However, Mr. Thomas, from Corporal Talbert's testimony, Mr. Thomas was in I guess I should say Corporal Talbert's testimony is not helpful. Narcotics, as far as finding it and the nexus to Mr. Thomas. However, Officer Williams did interview and Mirandize the defendant, and the defendant did state that he knew of cocaine in that back room, and the closet that he was in was also in the back room, and that he knew of, or that he sold cocaine. And just because he sold cocaine doesn't mean that the cocaine on that day was his. However, I do believe people have met their burden of proof to show, as probable law standard, that Mr. Thomas had the right to control those narcotics. It says here in the jury instructions, I'll read it. Possession does not necessarily mean ownership. Possession means that either one, the person has actual physical control of the substance, which is not this case. Two, the person has the right to control substances, even though it's in a different room or place. It says that possession may be joint, where two or more people each share the possession. It is not enough that the defendant really knew about the substances, which he didn't know about, but that the defendant possessed the substances only if he had control of it or the right to control it, either alone or together with someone else. And I do believe that the defendant had the the right to control the drugs that were on the bed in the room in which he was hiding in that closet. So with that, I will have Mr. Thomas. As Mr. Thomas bound over for, the arraignment on the information on all counts with the date of March 17th, since he is not in custody at 9:00 a.m.
Thank you.
Thank you. Did Mr. Thomas take on this case? I thought,
To my knowledge, no.
okay, I have a paper from here. I'm gonna clear that up for.
Here.
One moment. I just thought when I was fishing through the file.
Your Honor,
Yeah.
I think I believe the first time we were supposed to have a hearing, he was late. But the cases were moved and
Okay,
at that point, and we found Tuesday.
okay.
So he should be fine on his file.
I'm gonna take that out of the file once I find it. I saw it when I was fishing through it. I'll make sure I take that out and make it the correct notes.
Thank you.
All right, anything else before we go to record?
Your Honor.
Okay, all right, you have the rest.